Hello, welcome to our module number 5 on environmental policies, governance, and future pathways. In this module, we shall be covering topics like key environmental acts and policy frameworks in India, role of government, NGOs, and institutions. This we shall be dealing in this video as part 1. We've studied in our previous modules about the environmental acts in India, about the judgments that shaped judicial, legislative, and other intentions of judiciary in India and the parliament. There were various cases of MC Mehta, the staunch supporter of environmental cause, and various legislations. In this part, we shall be dealing with those environmental legislations in a little more detail and about the policy frameworks in India, about what is India doing in its governance. Linked with that, we shall be studying about role of government, and as important as government is, the role of non-government organizations and the institutions, which could be individual centric from actions of you and I to big institutions like TERI, like Niti Aayog. We shall be studying about that in this video. So let's begin with the key environmental acts and policy frameworks in India. These were the acts that we studied in our previous module as well, where we studied about what is National Green Tribunal. It's that body where any violation of environmental law is dealt with. We saw a lot of litigation in the high courts and the Supreme Courts being the constitutional courts. And it was important that a separate forum is set up, and that forum, which was solely dedicated to environment, was set up by the National Green Tribunal Act 2010. The other acts, as we can see here, will be dealt with in detail in this video lecture. So India has a comprehensive legal framework for environmental protection. Why? The simple question is that India is a land of cultural and ecological diversity. It's not just people who are different from north to south, west to east, but also, let's see, we are a country who has Himalayas and mountains on its north, who has deserts in its west, who has tropical forest in its east, and we are surrounded by seas throughout our peninsula. So a country which is so rich in its ecologic diversity has to preserve nature to do justice to what is gifted to us by God. Earlier, there were no legal frameworks because people were conscious on their own to not exploit anything. When times got a little tough and the harmony between man and nature broke, movements like Chipko movement, Vishnoi movement, and other movements that we have studied in our previous modules came up. But gradually, with the advent of technology, urbanization, population, and whatnot, the tussle between man and nature grew. The selfishness, the greed of human grew, and we began to exploit the bounties of nature to an extent that many people suffered at the mercy of big industrialists, miners, miners, and other people who thought that development meant that they could own nature like anything. That's why a comprehensive legal framework for environmental protection was important. These key laws address all the gifts of nature: air, water, forests, wildlife, and something that's new from industries, the hazardous waste. These acts are enforced by various central and state authorities. We shall be dealing with them as I touch each act specifically. Environmental laws are essential to regulate harmful activities. Now, like I said, we began exploiting nature to such an extent that something had to be done to regulate such harmful activities of man, to protect natural resources. We've studied again in our previous module about what are natural resources, be it trees, be it fossil fuels, be it water or air, soil. These natural resources have to be protected. Ensure sustainable development. Now, we've studied extensively about sustainable development goals in our previous module, and where I told you that it's not just important that India becomes, or for that matter, any country becomes a developed nation. It's important that we are sustainably developed nations because we must know we're holding this resources, we are holding this Mother Earth for our coming generations as well. We've gotten this from our forefathers and we need to preserve it for the coming generations. So, to address all of these issues, there are many constitutional backings. Article 48A states that the state shall protect and improve the environment. 51A Clause G says that fundamental duty of every citizen to protect the environment. And India is also signatory to various international conventions, Stockholm Conference, Rio Summit, the Paris Agreement, which we shall be dealing on later. So, before I get into the know-how of these acts in detail, I'm sure you all are aware that we have the penal codes in every country where if a person does wrong to another person, the person can be prosecuted under the penal laws. Let's say a person A murders B, then B's family can sue A for murder. So that's under the penal codes where people are involved. But for environment, we need to develop a legal framework so that those who harm the environment are also adequately prosecuted and the people who suffer are adequately compensated. So I think it was our first module where we studied about what is environment. And I told you that it's everything that surrounds us quite literally. So firstly, we deal with the Environment Protection Act. The Environment Protection Act of 1986 is an umbrella act for the overall environmental protection because whatever we're going to study next, air, water, soil, resources, forests, everything comes under the environment. So this environment is an umbrella act for the environmental protection overall. This act was enacted after the infamous incident of the Bhopal gas tragedy, which I'm sure we are all aware of. But there was a big leakage from the Union Carbide, and it was a long, lengthy litigation where people in Bhopal are still suffering today. So this act was enacted as a knee-jerk reaction to the Bhopal gas tragedy, and this act empowers the central government to regulate emissions and discharges from industries, units, factory units, restricts industrial operations in sensitive areas. Now, you cannot set up an industrial unit anywhere, everywhere. Now, let's take an example of dense forest in Meghalaya. If that dense forest is so rich in its ecology, there's so many little life systems working in there, we cannot possibly set up an industry over there. So it is the central government under this act that regulates where industrial operations can take place. And it's not that even if one time an industry has been set up, it can go for as long as perpetuity. It has to be regulated, what it emits, what it discharges into the water, if it's treated, properly before its waste is discharged? And if it produces any hazardous substance, how is the same dealt with? The Environment Protection Act extends to the whole of India. I'm going to read out the objects from the Act itself, which says that the objectives of the Act are to implement the decisions made at the UN Conference on Human Environment held at Stockholm. So, the UN Environment on Human Environment, which was held in Stockholm, is where we derive most of our law under this Act. Secondly, to enact general law on environmental protection, which could cover uncovered gaps in the areas of environmental hazards, as the existing laws generally focused on specific types of pollution. Now, the earlier laws that existed were very specific to air, or a specific law about soil, or a specific law about not hunting. But this is, like I have written here, it's an umbrella law. And here we have the gaps which were left by the other legislations being covered up in this act. To coordinate activities of various regulatory agencies under the existing laws and creation of an authority for environmental protection. Now, if there's a state water conservation board or a central water conservation board set up under the Water Act, or there's an air board, pollution control boards under the Air Act, or noise pollution control boards under the Noise Act. So all of these have to be brought again under one authority so that there is harmonious functioning between all of these things and a collective effort to conserve the environment is made. To provide for deterrent punishment to those who endanger human environment, safety, and health. Now, what is deterrent effect? This act seeks to put forth a deterrent effect, meaning that to deter someone means to scare someone. Now, let's say the similar example where there was an example of that A murdered B, right? And B's family has prosecuted against A, and A has been hanged to death. Now, seeing the punishment that A got, many other people will feel scared to kill someone because they will know that if we kill someone, we will also be hanged to death like A was. So similarly, little deterrent effects are important for environment protection as well. If there is deterrence to someone's act, like even in Bhopal gas tragedy, the Union Carbide was punished with some odd dollar millions to recompensate the victims back here, which again was less of a compensation and damage, but all of these things, the penalties that add to a deterrent effect so that more people don't commit that wrong. So the Environment Protection Act defines environment as anything includes water, air, land, and the interrelationship which exists among and between water, air, land, and human beings and other living creatures, plants, microorganisms, and other things. We studied again in the previous modules about how relationships in the nature are formed between microbes, soil, plants, herbivores, carnivores, humans, and then abiotic components and biotic components. So all of that is environment. So the central government under this act has the power to take all such measures as it deems necessary for the purpose of protecting and improving the quality of environment. The central government is the key functionary under this act to improve the quality of environment and to prevent, control, and abate environmental pollution. How can now the central government achieve it? Now, India is a big country with a lot of diversity in every way, so states perform an important role here. The central government coordinates its actions with the state governments and other officers the IFS officers, or under any other law, if any officer is appointed under the Air Act, the Water Act, and then they plan and execute nationwide programs for the prevention, control, and abatement of environmental pollution, and lay down standards for the emission and discharge of environmental pollutants, and also restrict areas in which industry shall be carried out or shall not be carried out. They also conduct inspections and examinations based on how these industrial units should function. All of this is important from environmental point of view because everything is environment. Now, the central government, it's important to know that the central government has a key role to play under the Environment Protection Act. The central government, in the exercise of its powers and performance of its functions, can issue directions in writing to any person, officer, or any authority that they shall be bound to comply with the directions so issued. And what directions can they issue? To close an industrial unit, to regulate an industrial unit, or to prohibit certain manufacturing in that unit, to stop emitting discharges, how they are emitting it. The central government can also cut their electricity or water supply and other services. So that's how powerful the central government is under this act. Coming next to the Air Act of 1981. The Air Act aims to control and prevent air pollution, like the name of the act itself suggests. The Air Act was enacted by the Parliament under Article 253 of the Constitution of India to implement the decisions taken at the United Nations conference held at Stockholm, again the same, in which India participated. It was decided to take appropriate steps for the preservation of the natural resources of Earth, among other things, the quality of air. So, many of us who might see this video and belong to North India should be aware of smog, of how badly when the remnants of crops are burnt, the whole NCR area suffers. So this act, amid other things, establishes central and state pollution control boards, powers to monitor and regulate, establishes central and state pollution control boards, which have powers to monitor and regulate anything that pollutes the air coming from the industries and vehicles. Very recently, we've seen that the Delhi government is discarding vehicles which are 15-year-old. How can the government issue such directives under this act? Then a very interesting concept of vicarious liability. I will be sharing about what is vicarious liability. But before that, let me tell you about the central and state pollution control boards. So this act envisages two types of boards, the central board and the state boards. The union territories also have the state boards. All of this is under Section 3 of the Act. Now, the central boards, like we started in the Environment Protection Act, this role of the central government here is vested in a board which has its members, and the functioning and exercise is also again under the government. The state boards, under the governance of the state governments, there's a chairman and there are members of the state government. Then there are also people from different industries who, under their corporate social responsibility, the CSR of the companies, if we've seen that they are working towards the environment, we can also make them the board members and they can help us align progress and sustainability side by side. So powers and functions of the board, again, functions would be very generic. It would be to improve the quality of air, to prevent and control air pollution in the country, and you need to advise the governments about various policies that you can make, and you can set up certain norms which are important to uh, prevent the deterioration of the quality of air. So, coming to the concept of vicarious liability, the concept of vicarious liability is that whatever an industry has done, the members of that industry, the board of directors, are responsible for the acts of the industry. They are vicariously liable. That is, even if now it's not the members of the directors of the control board who are directly polluting the air, but it's their industry that's doing it. So they cannot take a plea that no, it's not we who have done it in our personal capacity. No, they are vicariously liable. And they will have to pay damages and compensation and take remedial measures for bettering what their industry has wrongly done. So it's mostly by the offense of the companies. Section 40 of the Air Act incorporates the principle of vicarious liability. This section provides that where an offense against this act has been committed by a company, every person who, at the time of the offense was committed, was in charge and responsible to the company for the conduct of the business shall be deemed guilty of the offense and be liable to be proceeded against and punished accordingly. So it's important so that people do not escape their accountability. Hence, the concept of vicarious liability is important. Now, on similar lines, we have the Water Act. Just like we studied the Air Act, there's also Water Act to prevent the pollution and control the pollution of water. Now, interestingly, in our constitution, water is a state subject, and therefore the parliament can exercise limited powers in its legislation, and that can be exercised only under Article 249 and 252. Other than that, states can pass a resolution that they will be governed by central acts, and these resolutions were passed by houses of legislatures of the states of Assam, Bihar, Gujarat, Haryana, Himachal, Jammu Kashmir, Karnataka, Kerala, Madhya Pradesh, Rajasthan, Tripura, and West Bengal, to the effect that the matters relating to prevention and control of water pollution should be regulated by the parliament. Now, these states that I mentioned have passed a resolution that they can be governed by the parliament. Now, the Act of 1974 was the first major environmental law in India. It's not a surprise because we're all well versed with the fact that Jal Hi Jeevan Hai. Even today, the government of India's Jal Jeevan Mission and Namami Gange projects or other projects which are extensively and intensively focused on water pollution and conservation of water are going on. So water, since the beginning, the life originated in water. So it's no wonder that the first major environmental law in India was also on water. Now, this, like the Air Act, also focuses on preventing and controlling water pollution and requires industries to obtain a consent before discharging waste into the water bodies. Now, industries cannot just discharge their waste into the water bodies, which sadly they do. And they say that there's no better method of disposal, but they need to obtain the consent. This consent, again, is not easy to obtain. There are many clearance certificates that you need to get issued. And many environmentalists protest till date that this is not a very healthy way of discharge, and all the effluents that go into the water harm the marine life, and there has to be a better disposal of such waste. In the state of Odisha versus Government of India 2009 Supreme Court, Justice Karju opined that the right to get water is a part of life guaranteed under Article 21. So this is an important question, and that under which judgment was right to life meant to include the right to get water. So it was this very judgment. The objectives of Water Act were to provide for prevention and control of water pollution, to establish again central and state boards for prevention and control of water pollution, to provide for conferring and assigning to such boards the powers and functions, and then to provide penalties for the contraventions of the provisions of this act, and to establish water testing laboratories. Very important. Because if you do not check the quality of water that's being thrown out into the water bodies, it's all going to surmount into bigger problems. So that's about Water Act. Next is the Wildlife Protection Act. I hope you remember that we studied in our previous modules where I said that wildlife is very important because of all the food chains, food pyramids, and ecological balances in this biome. We need to have wildlife. We need to have that diversity maintained so that we're not endangered. So it is a selfish act, but we need to preserve wildlife. So this act provides for a legal framework for wildlife conservation. It establishes national parks and wildlife sanctuaries, which are called protected areas. So under this act, there are two protected areas, sanctuaries and national parks. Again, a very important question. It also prohibits hunting and trade of endangered species, of course. If you're thinking why to conserve, we have our previous modules for that. What are the reasons of extinction of various species? Exploitation. And then the constitutional mandate under Article 48A, protected areas, sanctuaries and national parks, NTCA, National Tiger Conservation Authority, and Project Tiger, because what is tiger? A national animal. So saving wildlife is a core responsibility of mankind, not just in India, but even otherwise in the whole world. Animal populations are disappearing at an alarming rate. Severe endangered species of plants and animals. So we need to keep that in mind, that wildlife includes both flora and fauna, and both plants and animals are becoming extinct, and it's our duty, because we share this earth with them, to protect their wild spaces and not exploit them. So a report from the World Wildlife Fund, the WWF, has found that 52% of the world's animals have vanished in 40 years between 1970 and 2010. Populations of mammals, birds, reptiles, amphibians, and fish around the globe dropped 52%, according to the Living Planet report. Now, how sad is this? That these trends that we are seeing of extinction, of dropping in numbers, of animals dying, is so inhuman of us to do. This entire module and course on environment studies and sustainable development is to bring you closer to nature, bring you closer to being human and humane. As to the question about why should we conserve wildlife, the conservation of wildlife, if nothing at all, let's be just selfish and say that it's important for mankind to survive, because the extinction of wildlife will ultimately lead to extinction of human race itself. India had at one time was the richest and most varied fauna in the world. However, over the last several decades, grave concerns have arisen because of a rapid decline in India's wild animals and birds. We're doing poaching, we're doing hunting, and then we are surprised about how this depredation is happening. So, we need to preserve wildlife because that's how we can sustain the ecological chains. To give another example, destruction of wild dogs, dholes in Bhutan, was intended to protect livestock. Now, there's a wild dog named Dhole in Bhutan, and they were being killed so that they don't prey upon the livestock. But this led to a greater number of wild boars and a resultant crop devastation, causing several cases of abandonment by humans of agriculture fields. Now, what does this example suggest? This example where I talked about Bhutan dholes, that we must not play with nature. Nature has its own food chains and food cycles, and we must not interfere, let alone disturb anything. The constitutional mandate to protect the wildlife comes under Article 48A, which imposes an obligation on the state to protect and improve environment, including wildlife. Other than that, even if it's mandated in the constitution or not, it should come from within us because we have gotten this as a gift from God and we need to protect it. Now, the protected areas under the Wildlife Protection Act are sanctuaries and national parks. Now, national parks have a collector and sanctuaries also have a collector, and these officers of national parks and sanctuaries are the one who give permits as to who can travel, who can come inside these national parks, and without their permission the entries are prohibited, and if you enter, the authorities are well in their rights to penalize you. Lastly, under this act, is important to study about something that's also very important in these days because the numbers have been rather bleak: the National Tiger Conservation Authority and Project Tiger. Project Tiger was launched in 1973 for conserving the endangered tiger. Tiger reserves were set up for conservation of tigers in the country. There was a twin object. The first was tiger conservation, and the second was harmonizing the rights of tribal people living in and around tiger reserves. So the NTCA not only protects the tigers, but also the tribals of that area. Forest Conservation Act. This act has been passed with a view to check what do we do with forests, deforestation. So this act is passed keeping in mind to check the deforestation which has been taking place in the country. It aims at putting restrictions on de-reservation of forest and the use of forest land for non-forest purposes. Now, the Forest Conservation Act firstly regulates what is a forest, whether it's being used as non-forest purposes, and if something is already a forest, we should not de-reserve it as a forest. And if you need to de-reserve it for, let's say, you want to take out a highway from there and you need to cut it, central government's approval is needed for the same. This act aims to reduce deforestation, and the Compensatory Afforestation Fund Act of 2016 is very important because this act says that if for developmental purposes you need to cut or de-reserve forests, then you also have to do afforestation parallel to such cutting and provide funds for the same. The forest conservation case again is very important. because here the Supreme Court had voiced that forests are where most of the strongest biological density is present, and it was said that you shouldn't be cutting trees like that. So the judicial attitude towards conservation of forests has always been very supportive. And in this case, the Supreme Court issued interim directions that all the ongoing activities within any forest in any state throughout India without the permission of the central government must be stopped. So it was this case where Supreme Court put a ban on all the projects which were going on without the permission of the central government, and they were cutting trees. Coming lastly, the National Green Tribunal that we also briefly discussed at the beginning of this module. It's a special tribunal for environmental dispute resolution. It ensures a quick disposal of environmental cases and can order compensation and restoration of damages, environment, scope, and application. All right. So here what's important to know is that the National Green Tribunal works in certain principles like the polluter pays principle. The polluter pays principle says that polluter, the one who is polluting, he pays. The polluter pays principle. If you are polluting, you need to pay the compensation, and you need to pay not only the compensation of the damage caused, but also need to pay for the restoration for the people who have suffered. The scope and application is throughout India, and start. The establishment of the tribunal is under Section 3 of the NGT Act, which empowers the central government to establish the NGT to exercise jurisdiction, powers, and authority under the Act, and it was established in 2010, 18th of October. The composition of this act that there's a full-time chairperson, not less than 10, but subject to a maximum of 20 full-time judicial members, because it's a tribunal that will be redressing like the judiciary. So you need to have judicial members, and not less than 10, but subject to maximum 20 full-time expert members, which will be nominated by the central government. So this is how the NGT is composed of: the chairpersons, judicial officers, and the other members which are selected by the central government. The relief, compensation, and restitution is provided under Section 15 of the same Act, wherein relief and compensation to the victims of pollution and other environmental damage arising under the enactment specified in Schedule 1. You need to restore the damage which has been done to the people. You need to rehabilitate them. For restitution of the property damage, if properties are damaged, you need to restitute them as well. And of course, you need to restitute the environment. Reliefs are also granted. And again, it works in the polluter pays principle. So these were the legislative acts. Now, quickly about the policy frameworks in India. The National Environment Policy, Comprehensive Framework for Environmental Conservation and Sustainable Development. NEP is basically very much public-centric. The National Forest Policy, as the name suggests, is again for forestry. Social forestry focuses on afforestation, and National Action Plan on Climate Change, again very important. You could have a question on what's NAPCC. This plan works on including solar energy, energy efficiency, sustainable agriculture, green India, water and Himalayan ecosystems. National Water Policy, very much in debate and discussion these days, promotes sustainable water resource management. The key features are that water is an economic good, conservation and efficient use, participatory water governance. These are some other ancillary policy frameworks in India. And with all this that we have studied, the legislations, sorry, the legislations, the policy frameworks, the role of judiciary, various judgments, we can say that India is very extensively into a framework where we want climate, nature, environment, its gifts like forest, air, water, soil to be sustainably used and benefitably shared. And all of this is what we studied in a little detail than what we studied in our previous module. I hope you got an insight on these legislations, their objectives, and how the central and the states are working from the level top to bottom to conserve and preserve the environment in legislative ways. Now, before we go to our next topic in our next video, make sure that you know that there are legal frameworks, and if anyone exploits the environment, you can most definitely file a complaint of any violation of these acts and get justice done for environment and yourself. Role of government, NGOs and institutions is something we shall be dealing in our next video lecture with a brief recap of the same. Thank you.